This is LAWS13017, Civil Procedure, Week 9, Disposition Without Trial, Tutorial Problems 25 to 26. Okay, there was a couple of things from last week. One was about the injunction in the district court. And I was a bit equivocal about that, but what I discovered was that the district court can grant an injunction, but only in a very limited sense. And it just happened to be that problem, not other problems. So that's why I'm so hesitant about it, because it's not all types of injunctions. So what I'll do is I'll just share this little bit here, make that a bit bigger. So we're also looking at this question whether, or what was a superior court of record. And as it turns out, it's the state Supreme Courts, obviously Court of Appeal, it's a High Court, Federal Court, and the Federal Court, Court of Appeal, Family Court. But it does extend to district courts, but only to the extent of their limited jurisdiction by statute. And that's actually established by a High Court case. But having said that, and there's the High Court case there, Day and the Queen. But it was this provision here, because I went and had a look at the District Court Act, and Section 68 with its civil jurisdiction, when you flow all the way through it, it comes down to this bit here, and it says to restrain, whether by injunction or otherwise, any actual threatened or apprehended trespass or nuisance to land. And that's what we had in our problem, where the value of the land does not exceed the monetary limit or in lieu of addition to such an injunction damages, but not other types of injunctions. So just that sort of one. So yeah, so that clarifies that particular point. So I just wanted to just make sure that's clear. The other thing I did too is that I had a look at the timeframes coming up for this quiz. And because we're 1 week behind in our tutorials, so we're actually in week 10, you need to be careful because it's only 2 weeks to this quiz. So what I thought I'd do, and I in fact have done, is given you the answers for the last 2 weeks of the tutorial so that you can go through and have a look at enforcement, cost enforcement and appeal, so that you can start to get a little bit ahead so that you're ready for that quiz. The way in which this civil procedure course has been accredited, because this is one of the Priestley 11 units, there are very strict requirements as to what's got to be covered. So that's a reason why we have this quiz that covers all of the course, because we're supposed to assess all of the course. So it's just the nature of these Priestley 11 units. So just bear that in mind that this is coming up. And I know you've been fairly busy because of the assignments and things that you need to get through, but yeah, you need to get yourself a little bit ahead. Okay. There's been a couple of other issues too with the marking of the first assignment. If the people who did the QCAT version of it, because that was about half the group, and the other half went and did the magistrates court approach, either is fine from my point of view. But everybody got caught out by this Form 4 of SEPA, because we in the course have been largely talking about the necessity for Form 1 to be attached to interstate service. Okay, and in the actual problem issue, remember there was a company in New South Wales. So if you were going to serve them, the easiest way to do it was by post. The Service and Execution of Process Act allows you to do that under Section 9(1). But you actually have to attach the form. Now, the interesting thing about it is that Form 1 is for courts and Form 4 is for tribunals. So everybody used Form 1. Not that this carried much in the way of marks or anything, it was just a point. But I believe it's actually Form 4, because that's the form that deals with tribunals. And when you actually look at the QCAT Act, there's nothing there that says it's a court. It consistently refers to it as a tribunal, and it's got jurisdiction under that act and any other enabling act, but I can't find anything anywhere that suggests that it's other than a tribunal, in which case it seems to me you have to use the tribunal form under the SEPA Act. But anyway, it's one of those little quirky things with procedure. Yet if you go onto the QCAT site, they'll say use Form 1. Doesn't open up an interesting can of worms though, because if you use Form 1, arguably it's invalid. All those services interstate. So anyway, we won't dig too deep into that, but it's an interesting issue.
Stephen, there's a few messages in the chat thing there. Apparently section 164 of the QCAT Act says that it's a court of record.
164, sorry, 164 what?
It's in the chat there, which I can't quite see at the moment.
Yeah, hang on.
164 sub 1.
Okay. All right, well, that's interesting. All right, so let me just get the, where is the chat? There it is. You get a very odd screen when you've got recording here. Okay. How bizarre. All right, so it does get that by virtue of this act. Right. Okay, so I was wrong on that point. Oh, well, that's good. It saves all interstate service, but it doesn't really affect much in the scheme of things overall in terms of the marking or anything. It's just one of those things that I was curious about. Okay. All right, stand corrected. Very good. I will put that in to my study guide somewhere. Glad that was found, because I was having a quick look through that act and I couldn't find it in the jurisdiction sections, which is where you would think it would be. But anyway, all right, let's move on. So what we've got this evening, yeah, they're niggly, complicated little provisions, and the best way to actually explain them is through a table. So let's have a look at what's happened. So on the 1st of August 2010, it's pretty old, so don't worry about the dates. It's the timings of these things that are critical. Sally commences an action against Peter for damages for personal injury. Actually, I'll share this because it's easier for you to see it. Where are we? Okay, so you've got all of these things. So Peter makes a written offer to settle on the 31st of March for $220,000. The offer lapses 28 days later, 1st of June, etc. And you're asked what order for costs should be made. So the only way to work these things out is to do a timeline. So that's basically what it looks like. So you've got an incident which happens on the 2nd of June, 1st of August, the commencement of the action, 31st of March, there's an offer, Peter's first offer, okay? So there's a calculation of interest of $5,000 up to the date of the first offer. Then there's a second offer. So the extra interest is another $1,000. And then there's judgment for Sally, okay? So Sally's the plaintiff and Peter is the defendant. All right. The reason why we're calculating these interest rates or the different periods is it's really important to work out whether the judgment includes interest or whether the interest is in addition to the judgment. So what we're told here is the judge also allowed simple interest. Okay. So it's in addition to the judgment. But if the interest had been included in the judgment, then you'd actually have to deduct the interest awarded for any period after day of service of the offer when considering the cost calculations. So you've got to be very careful about the wording of the judgment as to whether it includes or excludes interest, because that can change your answer. Okay, so that's why I've got this warning here. Watch out, facts and other problems, because that can really catch you out. You've got to be careful about interests. Okay, so let's have a look at this table, because really this is the key to it all. So you can see how it's set out in terms of the person who makes the offer, and it can either be a plaintiff or the defendant. So you've got two groups of rows, if I can put it that way, the plaintiff under Rule 360, and if the defendant makes the offer under Rule 361. So they're the two things. So first question, who's making the offer? The next question is, who is the ultimate winner of this particular claim? So who was successful in the judgment? And then it comes down to these questions here. So with respect to the plaintiff, the judgment, you've got to ask yourself the question, is the judgment no less favourable? No less favourable, okay? That means it's got to be equal to or greater than the offer. So that's what the test is for the plaintiff. But look at the test for the defendant. It's different. Here it's, you can ask yourself the question, here is the judgment no more favourable. So that's less than or equal to the offer. So be very careful about the wordings of these things, because as I say, it's quite complicated. So the best way I've always found trying to teach this is with this table. So what I've done is highlighted in yellow the situation we've got on our facts. Okay. So the defendant made the offer. In fact, the defendant made both offers, didn't they? Peter is the defendant from memory. If we go back here, Peter, yep, he made the first offer, 220,000, and he also made another offer of 150. But let's look at the first offer. So the defendant made the offer, so it's a Rule 361 situation. Who won? The plaintiff won, didn't they? We're told that the plaintiff, Sally, got judgment, okay, but she's 25% contributory negligent. So that has to be taken off as well, which we'll look at in a minute. Then you're asked, is the judgment, or you ask yourself, is the judgment no more favourable than the offer? Now, the judgment is actually what she's receiving. So you've got to take off any contributory negligence, and you've got to look at the situation with interest. So we have to go down here and look at this. So the defendant made the first offer. So the judgment is 240,000 less 25% of that for contributory negligence, which is 60,000. So the actual physical dollar value is 180,000. Then you add the interest, which was 5,000 before the first offer. So if we go back up here, we can see that the interest calculation over that period is $5,000. So what we end up with as the judgment, as the judgment is 185,000. That's what she gets in her hand. You've then got to compare that to the offer using the test. Is the judgment of 185,000 no more favourable? That is it less than or equal to the offer? And what was the offer? It was 220,000. So the answer to the question is yes. Okay, so that then is the result, this thing in yellow. The plaintiff pays the defendant's costs on the standard basis after the day of service of the offer. Now, you think about that for a minute. The plaintiff pays the defendant's cost. Who won this? The plaintiff. What would be the normal cost rule? If you win, the other side pays your costs. But this is the exact reverse of that. Okay, so the cost rule, the normal cost rule, which you'll see when you do costs, has been reversed for part of it. So it's after the day of service of the offer to settle. And the defendant pays the plaintiff's costs on a standard basis up to and including the day of service of the offer to settle, unless a party shows no other order for costs is appropriate in the circumstances. Now, you might ask yourself, well, why is that the case? Why has this cost rule been reversed? Basically, it's been reversed because Sally stuffed up. Sally should have taken the offer. It was, you know, it was $220,000 on the table. She could have taken that and she would have been far better off than running this thing right through to trial and getting the ultimate judgment. So the cost rules penalise her. These particular set of cost rules penalise her. So
doesn't that sort of mean, though, that you need to have a crystal ball? Because
well, no, well, yes and no. It's a game. It's a gambling game. What these rules are trying to do is to force people to really think about offers to settle. Because if you play the game wrong, you can have an adverse cost consequence, which we've just seen. So what it's saying to you,
court decisions can go either way. Like, for example,
they can.
She was actually given more.
Yep.
But she wasn't. I mean, you're not going to know how much contributory negligence.
Well,
is going
yes
to occur.
and no. I mean, that's not necessarily as clear cut. So I'll just reiterate, what this is designed to do is to encourage parties to make offers to settle.
Stephen,
That's all one. Yeah, sorry. Go on. Yep, go on.
I just had another question about this that I can't get my head around, and maybe if you could explain it to me. And it's the difference between standard costs and indemnity costs.
Okay. All right.
And I'm just a little, I think I'm correct in saying that indemnity costs are higher than standard costs.
That's right. They're 100%.
Yeah, but I'm wondering, how come the plaintiff can get indemnity costs, but the defendant never can?
It's just the way these rules have been set up. They've designed this system to force people to take offers seriously. So they have to come up with a penalty. So,
it seems to me, though, that someone can initiate proceedings as a plaintiff,
yep.
and the big stick sitting over them is never as bad as the big stick sitting over the defendant. And I'm just wondering if there was theory behind it.
No, well, what they've tried to do is to create a penalty situation both ways. Maybe what we should just wait a minute until we actually look at that case, and then maybe that'll make it a bit clearer. Let's work our way through it, and we'll come back to that question because it's an important one. But let's work our way through it so everybody understands it. So, are we clear here on this penalty? So this is a situation where the defendant made the offer, the plaintiff didn't accept it. It turned out that the plaintiff recovered less at the trial in terms of the ultimate judgment, and therefore they got penalised. And they got penalised on a standard basis. Of course, they have to pay the other side's. The plaintiff has to pay the defendant's costs, even though the plaintiff won. And the normal cost rule is the reverse of that. Okay, so the idea is to encourage the defendant to make as higher offer as possible, because the higher they make their offer, the greater chance they're going to catch this plaintiff out, aren't they? And on the plaintiff's side of it, looking at it, the higher the offer the defendant makes, the greater the risk that they're going to lose out on costs. So there's a bigger incentive for them to accept the offer. So you can see it's pushing from both directions to try and get the parties to actually reach an agreement and settle without going to trial. And they want that to happen because trials are expensive, not only in terms of the parties in costs, but also for courts and governments having to fund all of the whole system. So they're trying to avoid having to have more judges, more courtrooms, and things progressing via litigation. Okay, so that's one part of it. Now we'll keep going. Okay, so the next thing is there's another offer, isn't there, later on? Okay, so there's another offer on the 1st of June. Now the interest is accrued a bit more and it's much lower. Okay, so let's have a look at this situation. So who made the offer? The defendant. Who won? The plaintiff. Now you ask yourself, is the judgment no more favourable? Is it less than or equal to the offer? So what the judgment was, we come down here, the judgment is 240,000 less the contributory negligence plus the interest, which remember there's a little bit more interest because it's later on. That comes to 186,000, and the actual offer is 150,000. Okay, so is the judgment of 186,000 no more favourable, less than or equal to the offer? The answer is no. So this is a different solution to what was before. It's the green case here. Okay, so the defendant made the offer, the plaintiff won. When you applied the question, is the judgment no more favourable than the offer? The answer is no. So in this case, the defendant pays the plaintiff's costs on the standard basis, which is the normal cost rule. So there's no penalty here for the plaintiff because if you think about it, the plaintiff did the right thing. They didn't accept the lowball offer. They just went to trial and recovered what they were entitled to. So these rules just say therefore they get the normal cost rule. The defendant pays their costs on the standard basis. So the standard basis works out at about 60 to maybe 70% of the actual costs involved in a litigation. The indemnity basis is 100%. Now, the indemnity basis is pretty rare. If we're putting aside these particular rules we're looking at the moment, Indemnity basis really only arises in a few sort of situations where there's breach of trust or arguments over wills, those sort of areas. Pretty much everywhere else, you're not going to get indemnity costs. You'll be looking at the standard basis. And that standard basis arises because often if these go to trial and there's a judgment, and if there's then a bill of costs prepared, that bill of costs is arguments over whether the full amount is entitled to be recovered under a bill of costs, and that's a whole other set of arguments and more costs. And ultimately, you only end up with about 60–70% at best for standard basis. All right, are we all clear on the first two offers so far of how we've ended up with those results? Okay, if you're not clear, yell out. The big question then becomes, we've got two of these offers. Which one applies? One of them's giving a penalty and one of them's not giving a penalty. So which one out of these two is going to apply? So the way in which you resolve that is you've got to look at the wording of the actual legislation. So you can see here I've said which offer and associated cost rule applies. Okay. If a defendant makes more than one offer favouring the judgment satisfying Rule 3611, the first of the offers is taken to be the only offer, which is 3614. So this rule here, that part of the rule there solves this question. It says, if the defendant makes more than one offer satisfying sub-rule 1. Okay, now sub-rule 1 is the penalty situation. It then says the first of those offers is taken to be the only offer for this rule. Well, we only actually have one offer that satisfies sub-rule 1. It's the penalty situation, and that is what the answer is. Now, if we had two penalty situations, in other words, there was another offer which also gave rise to this yellow box here, in other words, two offers leading to a penalty, then the answer would be the first in time. Because it says here, the first of those offers is taken to be the only offer for this rule. So you can see how that is resolved, that question, by the wording of this rule. Now, there must have been an incredibly diabolical mind came up with this, but that's how it works. Okay. All right. So far, so good. I should keep this chat open. Okay. All right. So that's that. Now, if we go back to the actual problem, assume that Sally made the offers, not Peter. Okay, so now we've reversed the situation. So it's not the defendant who was making the offers. We're now assuming that these offers were made by Sally, the plaintiff. Then you're asked what orders for costs should be made. All right, it's the same analysis, but a different table. Well, it's actually the same table. It's just a different part of the table. Okay, so let's think about this. So the person making the offer is the plaintiff. So instead of being under Rule 361, which we were looking at before, we're now under Rule 360, the previous rule. Who won? It was the plaintiff, Sally. Then you're asked, is the judgment no less favourable? In other words, is it equal to or greater than the offer? Okay, so we come down here and we look at our analysis, and here it is again. All right, the judgment was 240,000 less the 25% contributory negligence, which is 60,000, gives you 180,000. Then you add the interest before the first offer, which was 5,000, which gives you 185,000. Is that less than or equal to the offer? Now the offer was 220, so the answer is yes. All right, so we come back to our little box. So the answer was yes, wasn't it? So the other way around, God, carefully. Judgment is no less favourable. So is the judgment equal to or greater than the offer? So what was the judgment? The judgment was 185,000. So was it equal to or greater than the offer? The answer was no. So, actually, let me just check, is that right? Let's just check that again. Okay, with respect to the first offer, the defendant Peter has not accepted the offer. That's right. Judgment is less favourable than the offer. No, wait a minute. The plaintiff made the first offer. The judgment was 206,000 minus 109,000 plus 5,000. So it's 185,000. And you've got to ask yourself, is 100...
These double negatives are a little confusing.
Oh, I know, it's confusing me now. Even though I write the table to explain it. Hang on, let's get this straight. Is the judgment no less favourable? So the judgment was 185,000 and the offer was 220, isn't it? Judgment no less favourable. Well, the judgment is 185,000 too. So the answer is no, isn't it? So the defendant pays the plaintiff's cost on the standard basis. All right, now look at the second situation. Second offer. Okay, it's made by the plaintiff, Sally. The Peter hasn't accepted it. The plaintiff made the second offer. Okay, so it's 240 less 60,000, 180,000 plus 6,000 interest for the second offer is 186,000. So that is the offer. Sorry, that's the judgment, 186,000, and the offer was how much? 150,000. All right, so asking this question here, is the judgment, so that's 186,000 equal to or greater than the offer? Well, it is, isn't it? So in this case, the defendant, which is Peter, pays the plaintiff's cost on an indemnity basis, unless the defendant shows another order for costs is appropriate. Now, let's just think about that for a minute. Okay, who won? The plaintiff. So the normal cost rule in that situation would be that the defendant pays the plaintiff's costs on a standard basis. So there's no penalty there. He would have to have paid it, the defendant would have had to have paid it on the standard basis. There's no penalty. That's why they put indemnity, because it's higher than what they would have otherwise had to pay anyway. So there's no incentive for them to accept the plaintiff's offer. See what I mean? It doesn't have that penalty that pushes them towards accepting the offer. And that's the reason, Stephen, why they've got the uplift from standard to the indemnity basis.
I understand that in the sense that the plaintiff can win even though his or her offer was less than what the judge said, and you just pay the standard costs. But if they made a really good offer and it got rejected by the defendant, they have to pay more. That's the basis for that. But why, when it's switched around, if the defendant wins and the defendant...
Well, no, hang on. The defendant hasn't won. The plaintiff has won.
No, I realise that, but I'm saying if the defendant wins... So
well, if the defendant wins, if the defendant wins, you're in this box here. The plaintiff pays the defendant's costs on the standard basis.
Yes, so let's say the defendant made a really good offer to settle, which was greater than what the judgment was.
Okay, well, then we're down here. No, hang on, then we're down in this part. We're down here. The defendant is making the offer.
Yep. Yeah. Why is there never an incentive for a defendant who makes a really good offer? It gets rejected by the plaintiff. The defendant wins the case. Why don't they have to pay costs on an indemnity basis?
I see what you mean, because the plaintiff pays the defendant's costs on the standard basis. That's right. There's not a penalty there.
That greater level of penalty for making unfair offers is not there for the other way around.
Yeah, I see. Yeah, I see what you're saying in that particular instance. I don't know why, actually, why they've done that, but they have.
Maybe when we do week 12, I think it is the costs part. It might be a bit more detailed there. Sorry for raising this now.
No. It's yeah, it's just a quirk of this system, isn't it? It's a little quirk of the system that they've done that. I'm not sure why they've done that.
Is this system in line with the Colbran system, or is it different because it's in statute and they just
It's a different sort of system. This is this is much more complex.
Probably it's an access to justice thing because you don't want to dissuade a plaintiff for enforcing their legal rights.
Yeah, but I've been sued 3 times for defamation, and all 3 times a plaintiff actually initiated proceedings just to make my life difficult.
Yeah, I'm not sure the answer to that. That's a little quirky thing of this system. And it's only in that instance, this one little scenario where that happens. If you look at it, all the other combinations, they seem to work in terms of pushing towards settlement. But the one you've mentioned doesn't have that penalty, which is very odd. But anyway, it is what it is. So you can you see how this works out in terms of how this table works and how it links to the sections?
It sounds like the lawyers would start doing a lot of horse trading.
Well, it's basically gambling. I mean, you don't have to make an offer, but if somebody does make an offer, it triggers these provisions. So, you got to be really careful. You got to be very careful in making the offer, and you've got to be very careful in how you respond to it. Yeah, sorry, I cut somebody off there.
No, Stephen, I understand your point about it being a game, but would a solicitor worth his or her value in salt not be able to advise the client about the desirability or otherwise of the offer?
Well, I would. I mean, the solicitor has the benefit of knowing the client's case and having access to all of the documents and everything at an early stage. I mean, these offers can be made at any stage. In fact, if you were confident enough, you would want to make them as early as possible, because then you get the greatest advantage in the game. But the risk is, of course, that other things may turn up at, say, the point of disclosure that you're not aware of, and it may change the game. Your chances of winning may change. So you'd have to be, you've got to be very careful about how you play this game, because if you end up in one of these penalty situations, it can be a lot of expense. But anyway, as I say, it's all designed to encourage settlement. At the end of the day, if somebody makes an offer and it's accepted early on, you may in fact be better off because you're not incurring all of the costs of having to pay the solicitors and the barristers and court fees and everything else. So maybe this, it's sort of a forced alternative dispute resolution in a way, isn't it? It's another scheme to try and get people to stop arguing with each other and come to an agreement, essentially. It's a very clever scheme, you must admit. It's very clever how it's been created.
It's ultimately understandable for a practitioner, but it's maybe a little bit harder to try and convince a client who is adamant about having their day in court.
Well, look, the client who's adamant about their day in court sort of loses a lot of that as the bills continually roll in. When they start to realise how much this is actually costing, then their desirability of the day in court may wane.
I mean, having said that, I mean, you've got some clients, and I mean, I'm only working in a small country practice, but there's still some clients out there with, where the bill would not necessarily faze them.
Well, true, you do get clients like that, but they're not in the majority. Yeah, if it's the principle of the thing and they don't care about the costs of it, well, they'll just keep going, won't they? And
we deal with one company all the time that doesn't give a damn about costs, and that's Qantas. They will never settle on anything. They just make silly offers and never accept anything we put to them.
Oh well, yeah. There you go. What can I say? All right. That's about it, I think, for that one. I'll work our way through that. And same if there's multiple offers, then basically what happens is that the rules, the way it works out under Rule 360 is just like in Rule 361. It's the one that has the penalty is the rule that applies where you've got multiples. And if there's two outcomes that have a penalty, then it's the first in time again. All right. Now, there was another little bit of this. If we go back, I'll just go back up the top here. I think there was a third part to the question. Okay, assume the original facts, except Peter made the second offer orally and not in writing. Well, that's an easy one. How do you answer that one? It's made orally and not in writing. These rules don't apply, do they? These things have got to be made in writing under the rules. If it's made orally, then that doesn't count. That's just a normal settlement offer. Sorry,
was it recorded? Is it a document?
No, it's not. It says made orally and not in writing. So there's no document. There's nothing which brings it within the terms of these rules. Basically, it's an oral offer to settle. And, you know, you can accept it, reject it, or say nothing in relation to it and ignore it. So that's not really going to have much in the way of consequences, well, in relation to the second offer. So the only offer that's valid will be the first offer. And that is the one that I think carried the sanction in our facts. So you don't have multiple offers, you just have one under the rules that applies. The second one, oral one, it's not under these rules, so it doesn't carry any consequence as such, except if it's accepted, and then offer acceptance lead to the end of the litigation. But we're not told that it was accepted. So there you go. So the moral of all of that, two things. Firstly, draw yourself a timeline of when things happen. Work out their simple interest rates for the amount of time. So they are simple annual rates, and you work out what the time period is. So if it's 3 months, you work out that it's 3/12 of the year by the interest rate, by the amount that will give you the interest. And then you've got to work out whether it was part of the judgment or in addition to, because that impacts on this as well. And then you use the table to work out who's making the offer, who's accepting it, who ultimately won, and then those various rules in terms of whether they're no more favourable or otherwise, the two separate tests. And that's how you work out these situations. All right, well, that's that. All right, problem 26. Problem 26. In the Supreme Court matter, the plaintiff, Julian Bloggs, and the defendant, Annette Hastings, have reached an agreement to resolve their long-running dispute. Annette's going to pay Julian $890,000. Okay, Julian agrees to no longer pursue the claim or any other potential claims relating to the alleged breach of contract. Okay, so this is settling. Then you're asked to draft the necessary documents to create the consent order. You will have to research the relevant forms to complete the consent order before a registrar. So that in itself is a question, is it before a registrar? So did anybody have a little bit of, anybody have any time? Probably not, to do the research, given you're all so busy at the moment this time of year. Where's the power in the Supreme Court under the UCPR to enable a registrar to give a consent order?
Section 666.
Yeah, there's an appropriately numbered section if
Yeah,
I've ever
the
come
devil.
across one, isn't it? Yes, that's right, section 666. So I'll put that up. Sections.
That one should be easy to remember.
It should be. It should be. So there it is there. It says the registrar may give judgment or make another order if parties consent in writing. Okay, so I know our facts they're going to, aren't they? They're all happy about this. And the registrar considers it appropriate. That's an interesting question, and we'll get to that second bit of the registrar thinking it appropriate in a minute. The consents must be filed in the registry. The judgment or order must state that it was given or made by consent and be filed in the registry. The judgment or order applies as if it's been given or made by the court. All right. A couple of forms. There's a form 59A, request for consent order of a registrar. And then there's the form order, sorry, the form 59, which is an order which requires 2 copies. So that's the draft order. And then an affidavit is probably not necessary. You can have an affidavit, but I'm not sure you really need one in this case. But anyway, so let's have a look at the documents. Well, maybe we should look at the practice direction first, because there's actually a practice direction number 4 of 2010 that governs this as well. So you've not only got the 666 rule, but you've got a practice direction. Just remember, you've got to be conscious of practice directions as well. So if we actually look at the practice direction, this is where things get a bit muddy. Okay. All right. So this is supposed to be a streamlined and cost-effective procedure to enable consent orders under Rule 666. Fair enough. So far, so good. The registrar is hereby accorded jurisdiction where it otherwise did not exist to hear and determine applications listed in paragraph 5. So it has to be an application that can be in paragraph 5. So we'll look at that in a minute. So it doesn't apply to adjournment of a hearing. Well, we're not adjourning a hearing as such, because there's a different procedure for adjourning a hearing. Well, we haven't got that. So it's got to fit within this paragraph 5. Now let's have a look at the sort of things that the registrar can give an order, a consent order in relation to. All right, directions that a matter be deemed resolved pending a final consent order or a discontinuance. So that probably fits our situation, don't you think? Directions that a matter be deemed resolved because the parties have come to a resolution and it's still pending a final consent order or a discontinuance. See, something has to happen to an, there's a claim being filed, it's been ongoing. That has to be resolved in some way. You don't really want it necessarily sitting in the registry, not resolved. Because if you're trying to resolve the dispute, you want it resolved so they can't come back again and get you. You don't want to reach a settlement that doesn't lead to that sort of outcome. The only downside of that for a defendant is if they discontinue, the rules automatically require them to pay costs. So there's an issue here about costs that's got to be resolved as well. Okay, now look what the registrar can do in B, the awarding or fixing of costs. So they can resolve this question of costs, including reserve costs. So reserve costs, as you'll see later when you do costs, are things that have been reserved. In other words, a decision hasn't been made. So there'll be maybe a series of interlocutory applications where costs have been reserved. So they're reserved pending the outcome of the trial and then probably will follow the outcome of the trial. So your interlocutory costs may not have been determined when that interlocutory procedure occurred. They could be reserved. So the registrar, for all intents and purposes, looking at these first two bits, A and B, can deal with the cost question and can deal with a final consent order and discontinuance. So perhaps that'll solve our problem. But just have a look through the rest of these things. An assessment of costs. So we haven't got anybody assessing costs or coming up with a figure for costs on our problem. Appointment of an assessor, well, haven't got that situation. Adjournment of an application, haven't got that. Transferring something somewhere else, we haven't got that. Gain transfer, a few things about transferring, well, that doesn't apply. Direction as to the conduct of a proceeding not under a judicial case management. Don't have that on our facts. Extension of time, we don't have that. Extension of an injunction, no. Security for costs, no. Stay, no. Setting aside of a judgment, no. Leave to discontinue a proceeding, well, that could be part of what we're dealing with. Leave to commence a proceeding under those acts. You haven't got that. Orders for mediation, no. Orders for corporation, no. Security of cost appeal, no. So on the face of it, our registrar could deal with this particular type of consent order. But I just want to run through them so you understand that registrars have very limited powers. What it then does is it goes in, it's part 6 here, and it actually tells you the sorts of things that should be more appropriately dealt with by a judge. And these are things that it's sort of indicating to a registrar that they should refuse and shouldn't handle. Next slide. Okay, so expert evidence orders. None of these things apply. Directions about limitations on evidence, trial by affidavit, directions in supervised case lists and commercial lists, complicated cases, no. Rectification of will, declaratory relief, guillotine orders, none of these sorts of things. Sanctioning of settlements. Now, that's an interesting one. See, sanctioning of a settlement. Now, we might say that this is sanctioning of a settlement, but what that's referring to here is really shown by the example for children. So this is where there's like a protective role by the judge. They want to make sure that a minor, if somebody is putting, say a guardian is putting up a settlement proposal on behalf of a minor, then that requires a judge to have a really good look at what's happening.
What if it's just a property settlement? Because that's
no. This is a particular sort of situation.
It's used children as an example, but does that
It
mean
is.
there's others?
This is looking at sort of the protective powers of the court to protect individuals under disabilities, and so I don't think it's necessarily a property settlement situation. You can see it again in this next one. See, de facto relationship orders relate to children.
I don't want to hear about property settlements. It's all I've done all day.
Well, you should be answering this question.
In a family sense.
Consolidations, we don't have, that's not consolidating any proceedings, no undertakings. It's not extensions of time. It's not cross-vesting. All of these things go to a judge. An order seeking dispensation from procedural requirement, no. And it goes on and on and on. None of these sort of things apply to our facts. So on the face of it, I think we're looking okay in terms of what the registrar can do. But of course, remember what these provisions said is that the registrar has to consider it appropriate. So, you know, the registrars are pretty conservative, but on the face of what we've seen from the practice direction, they should be able to handle this okay. That doesn't necessarily mean that you'll come across a registrar that says, no, I don't want to do it. And if that happens, then you're going to have to go before a chamber judge to get the order. But going before the registrar is cheap and inexpensive. Going before the chamber judge is a bit more expensive to do. So it looks like the registrar can do it. So if we come down here, then you've got to produce the documents. Okay, let's get past all of this. Here we go. So this is the first document. Okay. Request for consent order of the registrar. So consent is given to the registrar in making orders in terms of the attached draft order. So you've got to attach a draft order to this. All consenting parties have signed this. No other parties' rights or obligations are affected. As soon as that happens, if somebody else is affected by this, then it's really got to be dealt with by a judge. The consenting parties have complied with all the statutory provisions, if any. Order sought is within the jurisdiction of the court, which it is. Does not call for the exercise of judicial discretion. It doesn't, because we're relying on that practice direction, which indicates that this is something that a registrar can do. The order does not relate to a case on supervised case list, commercial list, or any other managed case. Well, it doesn't. So that's all good. So this is the request to the registrar to make this decision, signed by the respective plaintiff and defendant. Don't forget to put these little things on the bottom of these forms, you know, because that's part of the form. And then you actually have the actual order. So it's before the registrar, whatever the date is. Initiating document was the request, which is the previous document we just filled in. And the order of the court is this. Now, let's have a look at the terms of the order. The defendant pays the plaintiff the sum of $890,000 in satisfaction of the claim. This is the bit you draft yourself, okay? The plaintiff agrees to discontinue this and all potential future claims against the defendant in relation to the matter. Now, if you're settling this, if you're the defendant, you want to make sure that all of the potential claims related to whatever facts are involved here are settled and disposed of once and for all. You don't want to settle a bit of it only to then have another claim lodged and you suit again. You want to make sure if you're paying the $890,000 here, that you have ended the particular claim and any other claim related to that matter. That's really important in a settlement. If you don't do that, there's a risk that they could come back and sue you again on some other aspect of it. And you wouldn't be able to stop
this
them.
one, is there?
Sorry, what was that?
There was no interest involved in this one, so they're accepting an amount without any interest.
Yes, I mean, I didn't put interest in the problem. I could have, but I didn't. What I'm trying to say is with these settlement documents, you have to be careful. I'll just finish this last bit and I'll explain why. Each party bears its own costs. Now, the reason I've put that in there, because if you discontinue, there are rules, as you know, about discontinuance. And usually what happens if a party discontinues, they end up having to pay the other side's costs up to that point of discontinuance. Now, you don't want that to happen on these facts. This whole settlement is for $890,000, full stop. No extra bits related to costs, no extra potential future claims. So whatever you write here as the settlement, this effectively is the settlement agreement. It's bound up in an order of the court. So you've got to be very careful that you don't incur any additional costs. That discontinuance happens for this claim and any potential other claims related to the matter, and that the money is paid. And that's it.
Stephen, may I just ask here, I appreciate that the problem is about an alleged breach of contract, but if this settlement was being taken under some kind of statutory scheme, then that sort of shutdown clause in number 2, I presume, would have to be confined to the statutory scheme. So is this correct?
Well, hang on. Well, you have to be careful. You'd have to look at the nature of the statutory scheme, because some schemes, it's like the not the Trade Practices Act, the Competition and Consumer Law. You can't contract out of certain provisions. So you have to look at the nature of the scheme.
So if I could give an example, if an employee is suing the employer maybe under Fair Work or something like that, it wouldn't preclude the employee then pursuing a course of action in negligence or nuisance or.
I can maybe answer that because I'm a conciliator with the Fair Work Commission.
That sounds like a good time for you to pop in.
So I mean, our terms of
settlement.
Sorry?
Go on.
Yes, our terms of settlement have a mutual release in them, except you can't by law contract out of workers' comp and superannuation claims and workers' compensation. So I think it's something like, so it's all claims except for under statute, an industrial instrument or a common law for a work-related injury, illness, disease or death, or under superannuation legislation.
So there's your answer, really. You've got to look
but
at
everything else is everything else is finished.
Yeah. So basically what you want to do is finish off everything that you legally can. So if there is, as has been given by the example, if there is something under a statute that you can't contract out of, then you're stuck with that. But you would word it pretty much the way it was said. It was great. That's how you would have to frame your order here, if that was the case.
So no, I just asked Stephen, just asked Jackie a question about that.
Yeah, absolutely.
If an employee is settling, for example, an unfair dismissal claim, and the company agrees to settle for X sum of money, that's, well, this is not a question, that settlement would not preclude the employee, if they had a cause of action in negligence or harm or something like that, pursuing that cause of action.
So our release is purely what I said. It's under statute and industrial instrument or common law for a work-related injury, illness, disease, or death. That's exactly what it says. So I'm not a lawyer, obviously, but my understanding is there's certain things you cannot then take another cause of action against.
Well, yeah.
Would be issue a stop.
Well, hang on. Well, I was just going to say, we actually have an order here. So it's in effect like a judgment in effect, isn't it? So, yeah, but I mean, it hasn't, yeah, it actually hasn't been determined by a judge. So I think you might have problems with things like issue estoppel because it hasn't had a judicial determination as such. It's not a judgment. It's an order by an administrative officer in effect, rather than a judicial order.
So you're going to have trouble definitively getting rid of this, aren't you?
Yeah, a lot comes down to the wording that you can put in here.
What you start including issue estoppel and
no, well, you can't write that. All you can do is no, you can't list. You don't have to list it. It's just these statutory schemes that are going to create the problem.
And you can obviously have carve-outs, because so in some of our, even though there's a mutual release, a full release, apart from those things that you can't contract out of by statute, you can obviously have carve-outs for things like entitlements.
So what do you mean? Sorry, what do you mean by entitlement?
So, okay, so say someone comes to us for an unfair dismissal claim, but they still want to pursue, they didn't get paid notice, they didn't get redundancy or whatever. Right. You can still, if the other party agrees, you can have a carve-out clause that means even though there is a full release, they can, so in other words, the unfair dismissal claim is finished and they can't make any other claims other than to pursue entitlements.
Oh, okay. So when you say carve out,
yeah, sorry, a carve out. That's what we call it.
They're
carve
not
out clause.
For pursuing these other things that are carved out.
Yeah, so you would carve out the fact that they could pursue entitlements.
Right. Okay.
Yeah. Does that make sense?
Yeah, yeah. So looking at our clause here, it depends on how you word it, what's within it and what's not within it. So ideally, you would want to say that everything is within it. So to the extent that, unless you've got some statutory scheme, I don't know whether we have I don't think we have a statutory scheme on our particular problem. But if we did, then it'd have to be subject to whatever those limitations are under that statute that impact on the problem. But our problem here doesn't have that. So that's why I've worded it the way I have to exclude everything. Because really that's what you want to achieve. If you're the if you're the defendant, you don't want the plaintiff coming back at you again on some other basis on the same facts. This is supposed to be resolving at least the claim, but hopefully even beyond that, the whole potential for any other claims in relation to this. Yeah. Anyway, the upshot of this exercise was a couple of things. One, for you to understand the basis on which a registrar can make a consent order and see the sorts of things that they can do and the sorts of things that must go to a judge. This one falls into the things that they can do. So what would that then look like in terms of the forms that you have to fill in? So there's the actual order you're seeking, and then there's the other one, which is the request for consent. And this is a far cheaper procedure than going any. Doing things with a registrar is a lot cheaper than going any other way. So a lot of this is about trying to keep costs to a minimum. All right, 7 o'clock. Look at that, right on the dot for once. Have we got other questions?
Yes, Stephen, can I spoil that timekeeping? It's just a definitional question. In my reading, I've come across this expression about being a model litigant, and I haven't been able to find what that means.
This was something that the sort of Commonwealth government brought in for government agencies, that essentially this notion of a model litigant is one that doesn't, well, how can I say, it's fair, it's not ruthless, it takes a balanced approach to things, rather than somebody who say is fighting for the principle of it and will fight. Might be a Qantas example here that was mentioned earlier, that will fight to the end of the day to achieve an outcome, whether it's right, wrong, or indifferent. It'll just keep going. So a model litigant is one that'll only pursue claims that are valid, and it'll do so in an ethical and professional way. And it was born out of these Commonwealth government departments that were pursuing litigation. So that's where that's come from.
Thank you.
Yeah, I haven't heard that term for a long time, but there you go. All right. Other questions? We all right at the moment? All right. So you've got a bit of work to do. You should have got this second assignment out of the way. Now the thing to concentrate on is getting through these last few weeks worth of materials so that you're ready for the multi-choice exam at the end, the quiz.
Is it correct that it's 32 questions? It's like 3 questions on each week?
There's 12 weeks, so it should be 36 questions. If my maths still working,
I did my maths then,
on a Friday evening. Yeah, so it does have questions. So the way in which it's constructed is that there are questions for each week of the unit, and no apologies for that. That's come straight from the LPAB. We have to assess the whole course. So I've got a bank of questions that I've created for each week. And a good example of the sorts of questions are the things that you see at the back of each study guide. Although they only have 4 choices, this multi-choice exam has 6 choices. So it has more choices. So there will be 3 drawn from each week. And the 3 that you get aren't necessarily the same as the 3 someone else will get, because they're drawn randomly from a pool. Get my drift? That's how it's constructed.
So we're not all doing the same test?
No. There's a mixture of them. This has been constructed over many years, and it's been standardized. So the questions aren't any more difficult from one to another. They're just different questions. You may well get some questions that are the same as other people, but you may not.
Are they all multiple choice?
Oh, they're all multi-choice. Yeah, they're all constructed in the same way.
Does everyone generally get it done in 2 hours?
Yes, absolutely.
Good.
Do the questions only?
You need to have a general knowledge of what the unit's about. I mean, that's what we're trying to test here. But it produces consistent results year in, year out. I add new questions in, and sometimes I take, well, not sometimes, I do take questions out and fiddle around with it. But
Stephen, with the multi-choice, is there only one answer to them, or can there be
now with that, there is, I'm just trying to remember how this is constructed, because I've got another one in another unit that I do as well. Is there one answer or a combination of answers? I think
and does the question indicate if there is more than one? Because I've had.
Okay, so what I will do is I'll go back and I've got to review the multi-choice exam again anyway, because things change. For example, today I had to update the study guide for the new bankruptcy regulations that came in this year, 2021. So I need to go back and check to make sure that there's nothing in the exam that is referring to old material. So what I will do for you I can do that next week, is actually go through that exam, and then I can come back to you and tell you exactly how it's constructed, whether it's one that has one distinct answer. But when we say one distinct answer, that's a bit of a misnomer too, because you can have a situation in a question that it might say, it might have a question, and then it might say there are several results from this, and then list A, B, C, D, E, or whatever, and then the actual answer is, you know, choice one is A, C, and D of above. So it's actually got multi components to it. So there's one answer, but it's got multi. You have to actually understand the combined answer to answer it correctly. So, but I'll clarify that next week. How about that? And because I'm just trying to remember how it was constructed.
That would be fabulous. Thank you.
Yeah, so that just to allay any fears about it. And yes, people pass quite readily. It's not designed to wipe you all out or anything. It's just designed to see that you're actually understanding the broad principles that we've been doing every week. So the best preparation for it is a couple of things. One is to make sure that you're familiar with the rules, because you've got time to look up things if you have to, but it's that you understand the tutorial problems and how they've worked, and that you understand the questions, revision questions at the end of each week. If you can do that, then you shouldn't have any problem at all with this quiz. So I don't want you stressing overly about the quiz, but you do have to learn the course. And I do realize there is a lot in the unit, but we are required to test you to make sure that you've got a good comprehension of what the area is about. So, but anyway, I'll give you some more details next week, but I just want to go in, just make sure how I've constructed it. It's been a while since I've looked at it.
I do note from some of the other units that I've done, Stephen, some offer a practice quiz, which may or may not use the question, a different set of questions, but offers examples of those types of scenarios so that people aren't surprised by those when they do come to do them.
Well, I could give you some examples of questions. I'm a bit loath to actually create a practice because it's actually quite difficult to construct these things, but I can give you some examples of some questions. I can make up some new ones and give you, some examples. We'll take some old ones out and put some new ones in, but if that'll help you, if that'll allay fears about this, I'm quite happy to do that. But I will go back through. I want to have a good look through it anyway. It's been at least a year since I've seen it, so I just want to make sure what's in it again. But I'll do that next week so that you've got some advance. But the main thing now is that you try and catch up with these materials, because as I say, it's only like, I think about 2 weeks away, this quiz. It's not that long. So, okay. All right, we'll stop there. As always, if you've got any questions, email me. Some people give me a ring, that's fine as well. We can go from there. All right, we'll see you next week. I also posted up those answers for the last 2 weeks of the course into the team site. So if you go in there, you'll see that they're all there now. Okay. Because don't ignore enforcement, because it's a really important area. You have a good grounding on how enforcement works. So at the end of the day, if you can't recover anything for your client, they're not going to be too happy. All right. I'll see you next week.